Hello, dear student. Very good evening to all of you. So, dear student, we are going to discuss about OPSC previous year question. So, already we have discussed last four video up to 20 question number 8. So, from question number 80 towards 103. So, today we are going to discuss. It is not only we are not going to discuss about only the answer. We are going to see about all the important provision, each and every options. If anything current development is happening, we are going to do that's discussion also. So before starting that, please confirm whether everything is okay or not, like my audio video, everything is okay or not, so that we can start our session in a very smooth way. Okay, chaliye. Yes. So yes. Okay, let's start. So starting from the question number 81. So what is the question? So which of the following? So question is very simple. So which of the following is not a department under Ministry of Finance? That means which of the following is not a department under the Ministry of Finance. So if you look into Ministry of Finance, you'll find five departments. So first one is about Ministry of Revenue, earning income. Then expenditure. The next is economic affair. Next is investment and public asset management. That is called DIPAM, Department of Investment and Public Asset Management. So next one is about the financial service. So these are the five department of Ministry of Finance. Okay. So but what kind of department is given? So it is given a Department of Economic Affairs. Yes, it is correct. So Department of Expenditure, correct. Department of Revenue is correct. Department of Banking Affairs. So this is not a department. Okay. So this answer is not correct. So that is D is not correct. Okay. See, this is asking not a department. So always you have to mark whether it is correct or incorrect. They are asking in the question. Okay. चलिए आगे बढ़ते हैं. So the department, the banking affair. So department of banking affair, there is nothing like that in the Ministry of Finance. Rather, we can say that banking affair is handled by the Department of Economic Affairs. So Department of Economic Affairs is handled by the banking related matters. So next important question is, so all India WEAF conference is organized by Ministry of Parliamentary Affairs, Chief Minister of the States, Speaker of the Lok Sabha and Vice President of India. So it is actually Ministry of Parliamentary Affairs. So we are actually party leader. They issue directions to the party member to ensure that there should be sufficient number of people are present in during the discussion. So dear student, please comment my voice is audible or not, and anything if you are facing any kind of problem, please keep interacting with me. And very good evening to all of you once again. So here let's see discuss about we are going to say about detail about the WEAF. So all India WEAF conference organized by Ministry of Parliamentary Affairs. So it is not about any other, it is Ministry of Parliamentary Affairs. So Government of India. So it is organized under Government of India allocation of business rule. So this Government of India allocation of business rule basically allocate which ministry will have which department. So it is given to Ministry of Parliamentary Affairs. Very good evening. So hope my voice is audible, everything is okay. So under 1961, so it is under the Article 77(3). That is what allocate different business to the different ministry. So the purpose to discuss various aspects of parliamentary democracy and to come out with some concrete solutions. Not only to discuss about various aspects of the parliamentary democracy, but also come out concrete solutions. So there is no mention of the WEAF neither in the constitution nor in the parliament. So it is not mentioned in constitution and parliamentary. So this can be a very good question. So WEAF is mentioned in our constitution, WEAF is mentioned in our parliamentary rule. It is not mentioned anywhere. Okay. So all India WEAF conference first time held in 1952 in Indore. So you have to remember this. So first time there is a WEAF conference held in 1952 in Indore. Okay. So next important question. So the purpose of Uniform Civil Code incorporated in Article 44 of Indian Constitution is for what? So we know that uniform UCC, Uniform Civil Code, basically wants to establish uniformity in the law. देखो, in case of criminal law, if a person, let's say Hindu, a person is from Hindu and person is from Muslim, if both anyone kill a person, so both will face the same penalty. Na? In criminal law, there is almost equality in terms of law that is applicable to the different religious person. But in case of civil law like marriage, adoption, succession and divorce, here Hindu is driven by Hindu code will and Muslim is driven by their Muslim personal law. So that is a different for the different religious community. So that is what led to the violation of equality before the law. So Article 44 of Indian Constitution talk about providing uniform civil code in our directive principle of state policy of Indian Constitution. So states shall endeavor to secure uniform civil code for citizens throughout the territory of India. What is the objective? To address the discrimination against the vulnerable group and to harmonize diverse cultural group across the country. So basically main objective of uniform civil code, to ensure that those who are weaker section, we need to protect them, because weaker section like women, so we need to provide the right. So here the answer, the purpose is basically it's promoting national unity, because it is creating separatism, it is creating separate ideology between different community. If we are going to have single law for the civil aspect, like marriage, adoption, succession, divorce, so that is what promote the national unity. Okay, so it aim to protect the vulnerable section including women and religious minority, also promote unity. Okay, so uniform civil code call for formulation of one law for India which should applicable to all religious community in matter of marriage, divorce, inheritance and adoption. So you can clearly see it, their objective. Okay, so next important question is, the policy as a rational choice in competitive situation is game theory actually. So it worked to come up with a solution regarding the social situation that arises among the various actors, strategically producing an optimal decision for those competing actors. So these are actually one time question, so just remember that this is game theory. Okay, so next is keeping control over the delegated legislation is a power of DES. So what is delegation legislation? देखो, parliament make law in a form of skeleton. Parliament makes skeleton law, that means a broad outline it can be prepared. For example, citizenship, CAA, Citizenship Amendment Act, it's provide for, we will provide citizens to the six religious community from 3 countries, but how we are going to implement at the ground level, so that is what provided by the administration. So that is what called delegated legislation. So parliament make the skeleton of the law, and detailed provision of this law is prepared by the executive or administration. So that is what called delegated legislation. So there should be a control over the delegated legislation. So what are the mechanism available for control? So one mechanism is, there is a committee called Parliamentary Committee on Delegated Legislation. Here it is again written Committee on Subordinate Legislation. So this can also controlled by the Supreme Court also, but the option they are given very confusing. So Rajya Sabha, Lok Sabha, Supreme Court, so anyone can be true. So OPSC is not evaluated this question. So you will have to remember, since Parliament cannot deal with every aspect of governance system by themselves, so they delegate these functions to the authority established by the law. This delegation is noted as, commonly called as delegated legislation. No, it's not possible for parliament to make law for each and every provision, so they have delegated this provision for the administrator to make this law. Okay, so regulation and bylaw made by the local authority will apply only in area under the legislation. Okay, so there is a committee of parliamentary also, this committee of legislation which provide for power confer constitution. So they actually control whether the delegated legislation that has been prepared, whether they are in sync with whatever the law made by the parliament. Okay, so this is the controversy this here. So delegated legislation is controlled by parliament and judiciary both. So here it is given Lok Sabha, Rajya Sabha, quite confusing. So the main objective is to control, to look there is no abuse or unnecessary use of power given to the rule making body. Through an act of parliament, parliament has the full authority to permit any person or authority to make such law. देखो, if parliament is given a skeletal form, so the executive means the administrator and government need to implement this law as per the provision given by the parliament. They should not misuse that power. To control that, this power is given to the parliament as well as the judiciary. Okay, so this is what the point, so you have to remember. So next important question is, the government, so governing council of Niti Aayog comprising of what? So the prime minister and all chief minister and export specialist, all chief minister, lieutenant governor, chief minister and union finance minister. So I think this is also not evaluated, so just read it, you'll understand. So we have established Niti Aayog, National Institute for Transforming India, in 2015. So that is what replaced the planning commission. So this is what act as a think tank for government of India. Okay, so composition, it is consisting of headed by the prime minister and the CEO, chief executive officer. Okay, prime minister is this CEO. So governing council consisting of chief minister, all the chief minister and UT. So governing council consisting of both prime minister and chief minister and UT. This is what called broad, all member are there. So specially invites, it can be expert specialist and practitioner. So what are the objective of Niti Aayog? Basically aims to foster the cooperative federalism. It basically promote bottom up approach. It promote bottom up approach here the state and it is union and local. So next is formulate plan and strategy for the India. So key function, formulate plans and strategy for the India, promote sustainable development, enhance innovative and entrepreneurship. So I have already given. So you can say about the governing council consisting of prime minister, chief minister of all state, and the chief minister of all the UTs and lieutenant governor. Okay, so this is the broad membership of the Niti Aayog governing council. So next important question is the chairman of the zonal council in India is headed by Union Home Ministry. So I've given detail about the zonal council. Just read it, you will get a lot of insight. So zonal council are statutory body. So they are not parliamentary body, but interstate council under Article 263, it is a constitutional bodies, but zonal council they are statutory bodies. So they are established under the Act of Parliament, like State Reorganization Act 1956. Not all regional council, because Northeast Regional Council is established in 1971. We are going to see. So Act divide country into 5 zones. They are northern, central, eastern, western and southern zone, and provide zonal council for each zone. And Northeast Council was created by separate act of parliament, that is called Northeastern Council Act 1971. For a separate act we have established the Northeastern Council. So composition you can see about different state under the north. So just read it. So this can be a good question. So organizational structure, so the chairman is always the home ministry and vice chairperson is the chief minister of the state including each zone. Okay, so member, I think the objective bring about national integration, arresting acute growing of regional consciousness. So these are actually objective of this regional council. Okay, so next important question is 124 constitutional amendment bill took in the form of DES. So actually 100 124 constitutional amendment act, it is took in the form of 103. That is what provide for 10% reservations to the EWS, economically weaker section. So this is what past question. So how they can ask, going to ask question, they can ask about last I've given all 7 8 amendment, last amendment, you need to remember that they can ask about what are its provision. Okay, so 99th constitutional amendment act we have passed in 2014. So basically it want to establish national judicial appointment commission, but it was later struck down by the Supreme Court because it is believed that it is what violating the separation of power. Then 100th constitutional amendment we have enacted, that is providing for exchange of land boundary between India and Bangladesh. 101 we have enacted for implementation of the GST. So 102 we have enacted for establishment of National Commission for Backward Class. So because before that National Commission for Backward Class was statutory body. Now we have made this National Commission for Backward Class as a constitutional body under Article 100, under the Constitutional Amendment Act 102nd. So 103rd Constitutional Amendment Act provide for 10% reservations to the economical weaker section of the society. Okay. Then 104 provide for it extend the reservations to the scheduled caste and scheduled tribe for next 10 years. Also abolish the the Anglo-Indians representations to our parliament and state legislative assembly. So 105 Constitutional Amendment Act, so identify, notify other backward class. So it restore the power, it given the power back so that state can identify the backward class within the state. And 106th Constitutional Amendment Act, it provide 1/3 reservations to the women in the Lok Sabha and state legislative assembly and Delhi legislative assembly, including seat reserved for the scheduled caste and scheduled tribe. So these are the few amendment you need to remember, so that there can be a very good question. Okay, चलिए आगे बढ़ते हैं. So the India borrowed the idea of directive principle of state policy from which constitution? So it is actually the Republic of Ireland. Okay, so the India borrowed the idea of directive principle of state policy from Constitution of Ireland in 1937, which is known as Irish Free State, later became the Republic of Ireland. So what are the key similar non-justifiable principle called directive principle? So you already know that DPSP are non-justifiable for their violence, but they are acting like a guideline, they are acting like a source of guidance for the state to follow this principle. So B.R. Ambedkar and Constituent Assembly adopted this concept for India's constitution. We are believing that this is very important, so we have adopted. So dear student, everything is okay or not? My voice is audible or not? So please keep interacting so that I'll have idea. So this idea is to provide for the basic objective of DPSP is to ensure that socio-economical justice and fundamental right basically ensure political justice. Okay, so combining the DPSP and fundamental right, we can say these are the philosophy aim to achieve political plus social plus economical justice to all our citizens. Okay, so next important question. So dear student, hope everything is okay. So next important question, which of the following is not a fundamental right anymore? So if you look into our original constitution, you will find that there are 7 fundamental right in our original constitutions, but you have deleted one fundamental right, so that is right to property. Okay, so answer is A. So initially right to property was a fundamental right under Article 31. So you have to remember that 31 provide for right to property of Indian Constitution. It guarantees citizen protection against arbitrary deprivation of property by state. However, property dispute and concern over the land acquisition led to the removal as a fundamental right. So you have to remember 44th Constitutional Amendment Act. Actually, it is not 42nd. So most of the students commit this mistake that this is the 42nd Constitutional Amendment. We have removed the right to property. No, it is 44th Constitutional Amendment Act. So was abolished and right to property was reclassified as a legal right under Article 300A. So now the right to property is protected as a constitutional right or legal right under Article 300A. So citizen can now use dispose property, but subject to reasonable restriction as imposed by the law. So now, previously fundamental right means very difficult to take a property, but now it can be taken your property by giving compensation. Government can acquire property for public welfare provided fair compensation is given. So unlike the fundamental right which enforced directly Supreme Court, dispute regarding property right handled through the regular legal proceeding. Now, if you have any dispute, so you can go through the regular court, not directly to the Supreme Court. But earlier, when it was part of the fundamental right, you have the right directly to go to the Supreme Court. So next important question, hope everything is okay. So next important question, which part of the constitution does the concept of welfare state find its elaboration? So again, it is directive principle of state policy. So I think you have seen multiple question from fundamental right, multiple question from DPSP, multiple question from basic structure of the constitution. So they are asking repeatedly. So you have to give more emphasis to this portion. Okay, the concept of welfare state find its most detailed provision in part 4th of Indian Constitution, which contain DPSP. So Article 38 state to promote welfare of the people by securing socio-economic and political justice. So state to promote welfare of the people by securing socio-economical and political justice. So Article 39, adequate means of livelihood, equal pay for equal work, protection of the worker. So these are, Article 39 is talking about, adequate means of livelihood. We have to provide equal pay for equal work, protecting workers. So Article 41, right to work, education and public assistance. So right to work, education and public assistance. So Article 42, just human working condition and maternity benefit. So Article 43 talking about living wage and decent standard of living for the worker due to raise the nutritional level and standard of living. So these are few features, unique feature that is what found on our DPSP. Okay, so next important question is right to freedom of religious is guaranteed under which article of the constitution? So it is actually Article 25 to 28. So Article 25, freedom of conscience, free profess practice propagate religious. So Article 26 is talking about freedom of to manage the religious affair. So Article 25 is given freedom of conscience, profess practice propagate of your own choice, that means individual religious freedom. Article 26 is given the group collective freedom. So Article 27, freedom from paying taxes for promotion of any particular religion. So Article 27, prevent the payment of taxes for promotion of any particular religion. So Article 28, freedom from religious instruction imparted in state funded. So that means if any institution that is being taking funding from the state government, so they cannot promote religious education. Okay, so next important question is, so the fundamental rights are enshrined in the Constitution of India in which part? So part 3 of our Indian Constitution provide for enshrine of fundamental rights. So fundamental rights are enshrined in the part 3 of Indian Constitution from Article 12 to Article 35. So these rights are essential for safeguarding individual freedom, ensuring justice, equality, dignity of all citizens. So they inspire principle of democracy and human right. So what are these 6 fundamental rights? Currently we are having right to equality, right to freedom, right against exploitation, right to freedom of religion, right cultural and educational right, right to constitutional remedies. So, and fundamental rights are justifiable. That means in case your fundamental right is violated, you can directly go to the Supreme Court and file a case there. So this is already given, but what OPSC or UPSC can ask, they can ask about which part contain what in future also. So originally constitution contain 395 articles. So originally we are having 395 articles and 22 parts and 8 schedules. So you can know about 395, 22, 8. But at present we are having 448, 25 parts and 12 schedules. So we have increased it. So part 1 is basically deals with union and territory. Part 2 is deals with citizenship. Part 3 is fundamental right. Part 4 is DPSP. Part 4A is fundamental duties. 5 is union. 6 is about the state, and 7 is talking about this provision is not there, but just remember 7 is about state in B area of the constitution. 8 is talking about the union territory. 9 is talking about panchayat. 9A municipality. 9B is talking about cooperative society. 10 is about schedule area and tribal area. So the next is 11 is talking about relation between union and state. So you have to remember 11 is between relation between union and state, and 12 is talking about finance property, not important, you can ignore it. Article 13 is talking about trade, commerce, intercourse in the territory. It is very important, so you have to remember it. So next, article 14A. Article 14A provide for tribunal. Article 14A provide for the tribunal, and 15 provide for the elections. So article you can remember article 17 provide for the official language. Article 18 provide for the emergency, and article XX provide for the constitutional amendment. So I think these are few provision you need to remember. XX for the constitutional amendment, article 18 for the emergency, article 17 part 7, not for article, part 17 for the official language, then part 15 for the elections, 14A for the tribunals. So 13 is state commerce intercourse throughout the territory of India, then 11 for the relation between union state, 10 is for the tribal area and schedule area. So 9B cooperative society, 9A municipality, 9 panchayat, 8 union territory, then 7 part B, so 6 state. Then you have to remember everything. Okay, so this can be a very good question in future also. चलिए आगे बढ़ते हैं. So next important question is, so Gandhian principle, the Gandhian principle or philosophy have been enumerated in which? So it is enumerated in the directive principle of state policy. So I think you know that directive principle of state policy that we are founding, it can be classified in 3 categories. So first one is Gandhian principle, second one is liberal principle, and third one is Marxist or socialistic principle. So the Gandhian principle or philosophy are reflected in the directive principle of state policy, which are outlined in the part 4th of our constitution. So these principles emphasize social justice, rural development, self-reliance, and decentralized, aligning the Mahatma Gandhi vision for self-sufficient and equitable society. So Gandhi's DPSP include promotion of cottage industry to support rural economy, organization of village panchayat to enable local governance, protect and improve environment, safeguarding forest and wildlife, promotion of education, economic interest of weaker section, including scheduled caste and scheduled tribe. So next is to prohibition of intoxicant drinks and drug to maintain the social order. So though these principles are not legally enforceable, they act as a guiding policy for the governance, ensuring that Indian state to implement law in line with the Gandhian ideology. Okay, so this is what important. So next important question: which of the following, dear student, hope everything is okay. My voice is audible, so everything is okay. Please confirm once. चलिए, so which of the following set bill presented in parliament along with the budget? So here it is, 3 bill is presented during budget. Finance ministry present 3 bills. So first one is finance bill that provide approval for the government to collect the taxes so that their consolidated fund can be full, and then appropriation bill give the permissions to expend spend that money. So finance bill is collection of money and appropriation bill is spending of that money. So we can say that finance bill and appropriation bill. So finance bill is containing proposal for new tax modification, and appropriation bill authorize government to withdraw money from the consolidated fund of India. So provide legal authority to spend allocated money. So essential for government expenditure as per the budget. Okay. So which of the following is the middle of the 3-tier panchayat system? So I think you already know that in panchayat system we have 3-tier structure. So gram panchayat, पंचायत समिति एंड जिला परिषद. ठीक है, सो मिडिल लेवल इज पंचायत समिति. ठीक है, पंचायत समिति. And gram sabha, these are actually members. Gram sabhas is the all those who are age more than 18 and having voter ID or eligible to vote are member of the gram sabha. ठीक है, all the person those who are more than age of 18 and they are eligible voter of that gram panchayat are called as the gram sabha. Okay, so I think you have know that. So answer is B, that is panchayat samiti. So in which chapter of Indian Constitution there is a mention of uniform civil code? So uniform civil code you will find in the DPSP, Directive Principle of State Policy. Okay. So it is Article 44 and Part 4th of Indian Constitution. So in case of dispute between two House of the Parliament over ordinary bill, case can be reported to. So there is a provision of joint sitting. So if you look into our Constitution, you will find 108th Constitution, article of Constitution provide for joint sitting of the Parliament. So it can be summoned for to resolve deadlock when any House of Parliament pass a bill and when other House reject the bill. One House passed, other House reject, or the houses do not agree on amendment made by the bill. Let's say first house passed the bill, it is transferred to the second house, and second house amended some provision of the bill, and that is what not accepted to the first house. So that is what led to the also joint sitting. So more than 6 months lapse when bill being received by the other house without being passed. So that is what led to the establishment or starting of the joint session of the parliament. Reason for holding the joint session: so to make a constitution, the maker of the constitution have anticipated situation of deadlock between upper house and lower house. So therefore, constitution provide for the joint sitting. Okay, so joint sitting to break this deadlock. So joint sitting reflect the importance of Rajya Sabha as a check and hasty against the law passed by the Lok Sabha. So if you look into since independence, only 3 times you have established joint sitting. So first one is dowry prohibition bill, second one is banking service bill, third one is prevention of terrorism bill. So dowry prohibition, banking service, and prevention of terrorism bills. So there are few exceptions where you cannot have joint sitting. So in case of money bill, there is no joint sitting because Lok Sabha is having primacy. Rajya Sabha only can delay for 14 days. But in case of constitutional amendment, so it is required two-third majority. So in case of disagreement within both house, there is no joint sitting is there. So article 118 provide for president of India may, after consultation with the chair of the Rajya Sabha and speaker of Lok Sabha, may make rule for procedure of the joint sitting of the parliament. So two article is driven the joint sitting of the parliament. They are 108 and 118 of Indian constitution. Okay. So who represent government of India while presenting budget to the parliament? So obviously it is finance ministry. So in our constitution there is nowhere mentioning about the budget. It is talking about annual financial statement. Okay. So the finance ministry presented budget before the lower house Lok Sabha and deliver budget speech. Since 2017 it is presented in the 1st of February. Earlier it was used to present last day of February, but now we are presenting on the first day of the February. The term budget has nowhere mentioned in our constitution, but Article 112 is talking about annual financial statement. Okay, so budget is a statement of estimate receipt, expenditure, and certain other element. Government of India for a financial year. So budget can be introduced in Parliament with prior approval of President. Okay, so it can only introduced by the minister, not any other person. Okay. So next important question. So dear student, hope everything is okay. So keep on commenting if if you don't have any issue. So when a bill is resolved by the governor for consideration of president, within what time must return the bill? So original in our original constitution there is no time limit for returning of the any bill. But recently there is a Supreme Court judgment that is being given in Tamil Nadu case. So we are going to see that. So this is even I am adding all this current affair, all this current development that is happening. I am also adding. So that is what going to be very helpful for your examination. Okay. So when a bill is resolved by the governor for consideration of the president, so following options are available for the president under Article 200. So he may give his assent to the bill, may withhold his assent to the bill, may direct the governor to return the bill for the reconsideration. So there is no time limit in our original constitution. But Tamil Nadu versus governor, Tamil Nadu governor case, so under Article 200. So it is not talking about 201. It's only talking about Article 200. So that means in case bill is given before the governor, so governor has to act within 3 months. Okay, so it is 1 month. So withholding assents and reserving for the president, so governor must act within 1 month. So 3 month return the bill with a message, 3 month reserve bill for the president, and 1 month granting assents to the represented bill. So these are the restriction given only in case of governor. So still there is no restriction on the president. So next important question is, the Chief Election Commission of India hold office for a period of 6 years or until they attain the age of 65. So this is what question. But recently our government amended the Election Commission Act, so they brought lot of changes to it. So we are going to see it very it's very important for your examinations. So key provision of 2023 Election Commission Act. So what is the commission, what is the qualification of election commission? So election commission must be secretary level position, must hold position equivalent to the secretary to the government of India. Secretary level position must possess expertise in managing and conducting election also. So search committee, so headed by leadership. So it's the search committee to search 5 member for appointment of the election commission should be headed by the law and justice. Compositions 2 member. So the apart from the law minister of law and justice, there should be 2 member rank equivalent to secretary or higher. Prepare, they provide the 5 name to the panel. So panel, selection panel consisting of prime minister, leader of opposition and cabinet minister nominated by the prime minister. So they recommend name to the president, and president appoint the election commission and chief election commissions. So resignation process, either the chief election commission or election commission can resign by writing to the president. So chief election commission, like Supreme Court judges, ठीक है, so they can be removed. So chief election commission can be removed just like the Supreme Court judges of impeachment process. And election commission removal required chief election commission recommendations. So tenure already 6 years or 65, whichever is earlier. In case of election commission is appointed as chief election commission, so combined age should not be combined duration should not be more than 6 years, and no appointment is allowed. Okay, so this is what very important for your examination, because this is what added in the current affair recently. Okay, so this is very important, so you have to study it properly. चलिए, so आगे बढ़ते हैं. So next, the Supreme Court of India enjoy power of judicial review, which implies that it can review the working of subordinate courts. So this is what called appeal. Appeal, if it is doing something from the lower court, it is called appeal. So review of its own judgment. So this is called court of record. So being a court of record, it can review its own judgment. So initiate case against its own discretion. This is called suo motu power. So declare law passed by the legislature and order issued by the executive as unconstitutional if they contravening any of the constitution. Yes, this is what the answer. So declare. So judicial review means power to examine order passed by the both legislature and executive of the central and state government. If order are found to be violation of the constitution, they can be declared illegal, unconstitutional and void. Supreme Court of India declared that judicial review is one of the important feature of our constitution. That is what called basic structure of the constitution. So it cannot be amended or it can be taken away by the constitutional amendment. So the term judicial review is nowhere found in our constitution, but it can be found under Article 30, 30, 32, 13, 32, 131, 132, 133. Okay? So this is what called judicial review. It can review the law passed by the parliament. It can review the rules, regulation passed by the executive to make it in sync with the constitution. Okay, so next important question, doctrine of basic structure emerged from which case? So it is emerged from the Keswanand Bharati case. So I think this question they are asking repeatedly 4 to 5 times in last 5 years. So we are going to see in depth detail about all the case evolution. So what is basic structure? Basic structure are the unique feature of our constitution. Without the basic structure, our constitution will not survive. So we need to preserve that basic structure. So this is what invented by the Supreme Court in Keswanand Bharati case. So according to that basic structure, so Supreme Court, Parliament cannot amend. Parliament is having amended power, but it cannot amend the basic structure of the constitution. Otherwise, it will ensure the damaging of our constitution. So this basic structure means it is acting as a limit on the amending power of the parliament. So this judicial principle developed in Keswanand Bharati case. So this is what acting as a limit to the amending power of the parliament under Article 368. So here you can see, so initially there is a dispute started after our independence, so whether parliament is having power to amend the constitution or not. So first one is about the Shankari Prasad Sharma case. So in this case, so Supreme Court said that yes, parliament can amend the amend the constitution fundamental right for implementation of any law. But in Sajjan Singh case, again it is also said that parliament is having the power to amend the constitution. But in case of Golokanath case, so it is said that Parliament is not having any power. Parliament cannot amend the fundamental rights. So under Article 13. So that means there is a restriction is imposed. So to overcome that, government enacted 24th Constitutional Amendment Act. So Parliament restored its authority to amend any part of the constitutions. So they have override the Golokanath case. So to overcome this judgment, Supreme Court given its landmark judgment in Keswanand Bharati case. So it uphold the amendment power of the constitution. That means constitution. That means Parliament can amend our constitution, but provided that this amendment cannot destroy the basic structure of our constitution. So next case, so Indira Gandhi, Nehru versus Raj Narin. So they are amended to invalidate the amendment, including electoral dispute should be outside. So they put that electoral dispute of Prime Minister, Vice President, President should be outside the judicial scope. So here the Supreme Court said that judicial review is the basic structure of the Constitution. You cannot exclude from the Supreme Court. So 42nd Constitutional Amendment again tried to put Parliament is having unlimited power to amend the constitution, and it should not be comes under the judicial review. So after that, in Minerva Mill case, Supreme Court said that judicial review is a basic structure of the constitution. So Parliament cannot take away by mere amendment. So Vaman Rao case, again it is also said that the judicial review is basic structure of the constitution. So Indira Sahani case, so it is provide reservations to 27% to the OBC. So established reservation limits emphasize equality in basic structure. So I think Kyoto Alohan case, I think you know about dealing with 10 schedule of the anti-defection. So it is saying that the verdict given by or the judgment given by the speaker or the chairman of the Rajya Sabha, so they are subject to judicial review. So SR Bomai basically deals with federalism, declaration of declare federalism, secularism, democracy as a basic structure of the constitution. So IRO Coelho case is very important because what state government are doing, they are putting certain laws that is what violating the fundamental right under the 9th schedule, so that they cannot be subject to judicial review. But in IRO Coelho case, Supreme Court categorically said that any law that is being placed in the 9th schedule after Keswanand Bharati case, they are subject to the judicial review. Okay. So basic structure, these are unique feature of our constitution. If we amend, destroy that, then our constitution will be destroyed. So we need to protect it. So basic structure like secularism, supremacy of constitution, sovereignty, democratic, independent judiciary, federalism, unity, integrity of nation, freedom, dignity, so welfare state, principle of equality, rule of law. So these are actually some of the basic structure of constitutions. So dear student, this is all about the polity. So we have completed last 5 year the polity analysis of OPSC last 5 years. So dear student, if you like this video, please like, subscribe to my channel, and please do share this video with a friend so that more number of students can get benefit. So dear student, if you have any feedback, suggestion, anything, if you like this, please do like and comment in our comment box, because your like, subscribe and comment really motivate us to provide this high quality content. Chaliye dear student, we have to end here. Chaliye, bye bye, take care, good.